Welcome to the Australian Law Reform Commission podcast.
Hello, my name is Matt Corrigan. I'm the General Counsel at the Australian Law Reform Commission, and thank you for joining us in what is podcast 5 in our series looking at corporate criminal responsibility. I'm joined by Sam Walpole, a Legal Officer here at the ALRC, and we're going to dive into some of that really nitty-gritty on specific offences. And for those of you who are just about to hit pause and a little bit unsure about what's going on, I'm not Nadine, and this podcast is slightly different from the others, but I hope you'll enjoy it as much as we enjoy putting this together for you. So, Sam, to start, perhaps you could explain the traditional role of the criminal law and why it's not a perfect fit when applied to corporate defendants.
Sure. So much of the practical and theoretical difficulties surrounding corporate criminal responsibility stems from the fact that a corporation is not a natural person like you and I. It is an artificial entity constructed by law. Criminal law was traditionally designed with real people in mind. We need principles of attribution to attribute the acts and states of minds of a natural person or persons to a corporation for a corporation to be criminally responsible. This is not a perfect fit, as you say, and while corporations are comprised of and act through individuals, corporate action is also greater than individuals. Corporations are greater than the sum of their parts. They can also act or fail to act in different ways to individuals. In a corporate context, systems of conduct, patterns of behaviour, policies, procedures and culture are critical parts of acts and omissions by corporations. There are many recent, prominent examples of this. The fees for no service allegations in the Financial Services Royal Commission are rather vivid illustrations. These involved allegations of the systematic charging of fees to thousands of clients for ongoing advice services that were not in fact delivered over several years.
Thanks, Sam. So we know that corporations are not the same as individuals. How do specific offences address the uniqueness of corporations and their modes of operation?
It's a good question, Matt. Specific offences are framed so as to apply only to corporations. They better reflect the reality of modern corporate action, and it's often through the application of deficient corporate policies, procedures, culture, norms of behaviour and omissions that result in corporate misconduct.
So when we're talking about specific offences, we're talking about offences that can't be committed by individuals?
Yes, that's right. So these are offences that are drafted, so they apply only to corporations.
And what are some of the examples of these specific offences in legislation?
There are two main existing types of specific offences, duty-based offences and failure to prevent offences. In the final report, the ALRC recommended a failure to prevent offence be created for certain transnational offences.
Now, I think what's potentially for our listeners the most interesting aspect of this part of the report is that in addition to those specific offences, the ALRC has recommended a system of conduct defence for corporations. What misconduct is that offence intended to address?
So in the final report, the ALRC has provided two hypothetical scenarios to which the offence might apply if enacted. These are just examples. What we showed was that the offence might be appropriate in cases of systematic charging of fees for no service, a scenario I mentioned earlier. Another example we discuss is where a business model is based entirely around prohibited advertising of therapeutic goods. In the final report, what the ALRC did was work through these hypotheticals and explain what sort of evidence would be required to establish the offence in these scenarios. What the ALRC has recommended is that, where appropriate, the Australian Government should introduce offences that criminalise contraventions of prescribed civil penalty provisions that constitute a system of conduct or pattern of behaviour by a corporation. This is novel in the criminal sphere, but it draws upon the established system of conduct or pattern of behaviour concept used in a number of existing civil penalty provisions. It reflects the fact that corporations act through systems and processes, as well as through individuals.
So when we say that corporations act through systems and processes as well as individuals, what do we mean by that?
So I mentioned earlier, Matt, about how corporations are greater than the sum of their parts. And what we mean by that in the context of contemporary corporations is, sure, companies act through their employees and their agents as physical persons, and they act according to systems and procedures they have in place. But there are also many other things that corporations do through automation and those policies and procedures that mean that the actions of the corporation can go beyond those of any one individual, or one act according to particular systems or procedures can have impacts far greater than if they were just done once by one person. For example, one employee or agent might fail to turn off an automated billing procedure or system, or not record something correctly in the database, and then that will lead to 1,000 instances of charging fees for no service or something like that. Another employee may pick up on that error, report it to a certain level of management, but it might not be taken further. This might be because of a particular system or policy, or it could just be the concatenation of all the different policies it has in place. This seems really complex, it seems really factually specific. That's because companies these days are very complex, large, changing, dynamic organisations, and that's why they have systems and that's why they have different procedures and policies, but then that can also lead to errors and also misconduct.
So are you suggesting that it is those systems and those policies that can lead to criminal outcomes as opposed to the acts or omissions of a specific individual working within the corporation?
Yes, and it might be the combined effect of several acts which together form a system that then has maybe not so much criminal characteristics, but at least contravenes civil regulation. And we say that in certain circumstances it might be appropriate that such system of conduct, to use the term in the recommendation, should be criminalised.
And so in that sense, what you're saying is that it is the aggregate of many individuals' actions in accordance with policies and procedures that might give the aggregate outcome a criminal flavour that the individual parts may not necessarily be in and of themselves.
Exactly, and that's the idea that the modern corporation is greater than the sum of its parts. It's not about finding the directing mind and will in a huge decentralised multinational, for example.
So you touched on earlier the link between the system of conduct and civil penalty contraventions. Why in the final report was the offence linked to civil penalties in that way?
So the ALRC recognised that certain systematic contraventions of civil regulation could well amount to conduct that could be considered criminal. The two key issues that ALRC sought to address, and I sort of touched on the first of these in our discussion just then, the two key issues we sought to address were, firstly, where business practices were conducted without regard to the requirements of civil regulatory provisions, and secondly, business practices in contravention of civil regulation that are adopted in a calculated decision to absorb the penalty and profit from the conduct. So we're talking about systematic and deliberate failures to put in place appropriate controls.
So Sam, you touched on the fees for no services allegations from the Financial Services Royal Commission. I think it's fair to say that there was a lot of public disquiet about the wrongdoing that was uncovered during the Financial Services Royal Commission. I think it's also true that people felt that a lot of the conduct that was found to be wrongful hasn't at this point and may never lead to criminal charges. Is that an evidentiary issue, or is it a question of law? And how may specific offences be relevant in that specific context?
So I think in that context, there's certainly been civil action taken in respect of that misconduct, and that's because that's how a lot of the provisions that were applicable were framed. Those did not, however, and those are more about specific instances of misconduct. The law as it stands, whether it be civil or criminal, however, isn't targeted really in this context or in that context to looking at those systemic failures or systematic failures which this offence seeks to capture unless you can bring it within statutory unconscionability, which is a civil regulatory provision. So we would suggest that the benefit of this sort of offence or regulatory provision, even if it's used in a civil context, is that it's actually capturing these sort of systematic wrongs or systematic contraventions of the law, which sort of is part of the narrative of the misconduct, but isn't necessarily able to be captured by the current law and isn't really captured by, say, charging a particular individual in the corporation who actually executed the conduct, for example, or attributing that individual's conduct or state of mind to the corporation.
Thanks, Sam. I think what you touched on there is really interesting because certainly some of the evidence that came out of the Financial Services Royal Commission was that a lot of the conduct by corporations was alleged to have been occurring absent anyone knowing that it was going on. would a system of conduct type offence get around those concerns that there is illegal conduct or conduct that breaches civil law where it's not clear that you have executives or senior executives aware of what's actually happening?
Yes, I think the real benefit with the system of conduct approach is it actually allows you to use the operating procedures and the methods of work, whether documented or just in reality, of the corporation, and that's all part of the sort of narrative of the misconduct, as we saw in the Royal Commission, to establish an offence and to explain why contraventions of the law occurred. But at the same time, we're not just transforming civil penalty provisions into a criminal offence, because there's going to still be the need to attribute fault elements to the corporation. And that's so this offence is about, systematic wrongdoing, systematic and systems, ways of working that could properly be seen to be criminal.
So you've given us a couple of examples of circumstances where the ALRC thought the offence provision might apply. Do you want to walk us through in some detail how the offence provision works in practice? What does a system of conduct type offence look like in terms of its elements and its construction?
So in terms of the final report, the ALRC presented a draft model offence to illustrate what this type of system of conduct offence might look like in this context. It's a draft, but it shows the key concepts. The elements are the prosecution would have to prove particular conduct, so that's the constituent acts or omissions, by a corporation. The fault element for this element would be intention or recklessness. It would then have to prove, as the prosecution would have to prove, that objectively this conduct constituted a system of conduct or pattern of behaviour. As this is an objective assessment, the fault element for this we think should be absolute liability, and that mirrors existing civil regulation using that concept. And finally, it would be necessary to prove that the system of conduct or pattern of behaviour would result in two or more contraventions of the same prescribed civil penalty provision, or a prescribed civil penalty provision with similar characteristics, and that the corporation was reckless as to whether the system of conduct or pattern of behaviour would have such a result.
Thank you, Sam, for walking us through that. If I can just touch on a couple of those elements of the proposed offence in a little more detail. When we talk about effectively a jury determining that conduct by a corporation constituted to a system or a pattern, how do we determine that? Well, what is the standard by which you determine that particular acts and omissions form a system or a pattern?
So it's about, there's actually quite a lot of case law on this point now. It's extremely fact-specific and contextual. It's a contextualised assessment of the conduct, looking at it as a whole and looking at its features and whether it shows systematic or a pattern of behaviour that then amounts to something that breaches the law.
So Sam, let's assume for a moment that this offence has been enacted. If I'm a corporation, how do I ensure that I don't breach this? How do I ensure that there aren't systems and patterns of behaviour within my business practice that are contributing to civil penalty breaches? How do I identify these systems and patterns of behaviour so that I can address them?
So I think partly it requires corporations to be aware of their regulatory requirements at the outset, and we think that's appropriate, given that should be part of sort of licence to operate, if you like. It also, what it would require is the corporation to have systems in place that are effective and that meet those regulations. This offence is not going to apply to a corporation where some rogue operators in the corporation go against the systems and policies the corporation has in place and then charge fees to people that are no longer customers or something like that. It's about where there is conduct either formally in a formal system or just in a pattern of behaviour that can be shown to be systematic, and it's not about proving multiple contraventions or multiple occurrences. It's about, and the cases are quite clear on this, it's about going the next level and showing it was systematic. It's a characterisation of the combination of all the conduct in its context. So if you have adequate systems that respond to the regulatory requirements and say there is a contravention of a civil penalty provision, that won't come off in this offence.
Thanks for that. So one of the aspects of the offence provision, as you've just described, is the link to these civil penalty contraventions. a clear question then is, how do we really distinguish between something that is necessarily criminal rather than just multiple civil penalty contraventions? May they be inadvertent or otherwise?
Yeah, so I think I've covered some of this, but I think there was a concern about this raised throughout the inquiry, and this was something we were alive to throughout the inquiry. It was emphasised in submissions. The type of offence recommended is directed at systematic corporate misconduct, such that it warrants criminal sanctions. I've explained that with you just then. But also the draft offence is targeted, and some of the concepts we use deliberately narrow its scope. For example, the system or pattern conduct, the concept itself, and the requirement to prove fault elements to a criminal standards. This actually, while it can be applied to a range of different instances of systematic misconduct, it also confines the possible factual scenarios that the offence might apply to.
Thanks, Sam. That's really helpful. And in the report, do you envisage that the draft offence would apply in all regulatory regimes or to some civil penalty provisions? What's the scope of the offence provision?
So, put it shortly, no. We've recommended the offence apply only to prescribed civil penalty provisions. So we did recommend that a charge may be able to be proven through a system of conduct or pattern of behaviour that would result in two or more contraventions of the same prescribed civil penalty provision or one with similar characteristics, but ultimately it's a policy decision in a particular context. But for example, it's conceivable that a particular system of conduct could result in contraventions of differing false or misleading representation provisions across the same statute or across different statutes, but the systematic wrongdoing might well be the same. This recommendation is about providing an additional regulatory tool in respect of systematic misconduct that should be denounced, or whether the deterrent effect of a civil penalty proceeding will be insufficient. It's also possible, of course, that there may be scope for greater use of this system of conduct or pattern of behaviour concept, both in civil regulation as it is presently used in the positive law, and in a criminal offence detached from civil penalty contraventions altogether.
Thank you, Sam, for taking us through these recommendations from the ALRC's final report. There's quite a lot of detail there. Can you provide listeners with one key takeaway regarding specific offences and the ALRC's recommendations?
Good to speak with you, Matt. We think the key point is that specific offences are a promising avenue for developing more effective corporate criminal law. They have the benefit of paying greater regard to the reality of contemporary corporate behaviour with less of the artificiality of traditional attribution principles.
Thanks, Sam. I encourage listeners to head over to the ALRC website to download the final report. The full list of recommendations can also be found in the summary report if you'd like just a quick overview. Join us for the next episode in this series. Nadine will be back for that, and that's going to be covering individual liability with Sarah Fulton. Thanks.